Hello and welcome to Legally Speaking with me, Tarun Nangia. Litigation with the government or involving the government in the courts of law is immense. While that is immense, sometimes there is a need to summon government officers. But if it becomes excessive through or by all the courts, right from the district level to the High Court to the Supreme Court, then governance will become difficult. The court has rightly recognized this. And two judges who have recognized this is Justice B.R. Gawai, Judge Supreme Court of India, and Justice Pardiwala, Judge Supreme Court of India. They both, as part of a bench in the case which is called State of Bihar versus Ghanshyam Prasad Singh, they recognized this fact and they said, and I would like to read it out before I start the show, that summoning authorities of state to court at the drop of a hat undermines the majesty of the court. The key word here is undermines. Insisting on presence of officers in court wastes precious time and could be spent in discharge of their duties. And such a practice must not be adopted as a routine. A very, very important statement coming from eminent judges like Justice Gawai and Justice Pardiwala. When they speak, the message goes down to all the courts, the high courts as well as the district courts. Why this is important? We have two experts who do a lot of litigation at the Supreme Court and also other forums. One panelist, namely Senior Advocate Atmanam Nadkarni, appeared in the case. I would like to welcome you. As you would all know, Senior Advocate Nadkarni has served as the Additional Solicitor General of India. He is very well aware of what kind of litigation happens in the government. So he'll give us that view as well. Mahesh Agarwal, of course, heads ALA, also argues in courts. He heads one of India's largest law firms at the Supreme Court of India. His law firm is one of the busiest at the Supreme Court. Good to see you, Mr. Agarwal, and looking forward to some interesting insights from you as well, because a lot of times the companies you represent, government is a party, officers have to be summoned. So I'll first start with Senior Advocate Nadkarni. You appeared in the matter. Take about 3 minutes. Explain us what this was. How was the court and how did you feel about the reaction given by Justice Pardiwala and Justice Bhushan Gawai?
Yeah, good evening. This matter arose, the state of Bihar came to the Supreme Court because the state of Bihar found that a particular division bench had summoned about 145 officials in 1 year period. And most of these officials were senior officials. So it was at that stage that the state of Bihar was perforced to come to the Supreme Court, challenging the order of summoning the additional chief secretary holding an education portfolio of the state of Bihar. I appeared for the state of Bihar in that particular case. In fact, the law on the point is very well settled. The first judgment the recent judgments was somewhere in the year 2007, where a bench of Justice Mathur and Justice Kaju, the judgment is delivered by Justice Kaju in the case of state of Gujarat versus Hussain Bhai Hirani's case. There in paragraph 10 of that judgment, the Supreme Court deprecated the practice and went to the extent of saying that it should not be for the satisfaction of the ego of the judges. Whereas in a given case, you can always summon the officials. It is not that the High Court is a constitutional court. And being a constitutional court under 226, you have enough powers to summon an official in case of non-compliance or so many other things. But what happens is, if you frequently resort to the habit of summoning government officials, then it creates a lot of flutter in the administration itself. Then came a recent order passed by Justice Sanjay Kishan Kaul. Justice Sanjay Kishan Kaul, while referring to the earlier judgments, deprecated this practice in the case of state of Uttar Pradesh versus Manoj Kumar Sharma. That's a recent judgment. Then, despite these orders, this particular court, a Patna High Court, was frequently calling officials. And the experience was not so good because the officers would be heckled in the open court, etc. Now, today, we are in a state of digital technology. Chief Justice of India has said that permit VC appearances, etc. if you really want to get through some matter where you don't get enough assistance in the court and you want the officials to come and, explain to you certain things, you can always ask the official to appear on VC. I mean, nobody would be against it. Officers can always be called and asked to explain certain things. It is invariably done even by the Supreme Court that you please call your officials if the matter is highly technical or what exactly is the difficulty on the field. But just at the drop of a hat, calling officials, and that too in this case, the order in question was complied with fully. See, Justice Gavai's order, which he dictated, records that the order has been complied with. They record the statement of the other side, the petitioner in the content, that it has already been complied with. So there was no further grievance and there was no requirement to summon this particular official. Yet the High Court summoned the official, and that is how the Patna state of Bihar came to the Supreme Court. And that is how the order came to be passed. And we presented a list before the Honorable Court, the number of instances and the number of matters, and giving the names and the designation of these high officials who have been frequently summoned to the court. See, it should not be the administration of justice. There is also the administration of the state machinery. In fact, in this particular case, the Additional Chief Secretary was busy conducting a very important seminar in elsewhere out of Patna. So all these things, it is a waste of public time, waste of public money, waste of energy. I mean, for what reason are you summoning officials when the order in contempt has already been complied with?
You made a very fair point, and that has been mentioned in the order also, that if the court's directions have not been complied with, then summoning somebody who holds a position of importance in the government hierarchy makes sense. I'll take this to Mr. Mahesh Agarwal. I mean, for so many decades, you've been seeing litigation at the Supreme Court and other forums. Could you share with us some anecdotes and the importance of what Justice Pardiwala, Justice Bhushan Gavai have said, the importance of these directions?
See, it was very critical for the bench of Justice Gavai and Justice Pardiwala to give a clear message to all the high courts and the subordinate judiciary. It is very important to maintain a balance between the judiciary and the executive. Ultimately, both are performing a very important function. I'll give you a different perspective. See, we are appearing mainly for private clients. We go to a court, we file writs, directions are issued against the government, and many cases there is non-compliance. What am I interested in? What is a private client interested in? He's interested in compliance with the order. He's not interested in dragging a person to the court or humiliating a senior officer. And there are enough methods under the Contempt of Court Act, as also the exhaustive jurisdiction of the court, that an order of the court can be implemented without calling an officer of the court, without calling an important officer of the government. You can implement the orders. Insofar as clarifications are concerned, we have a clear system of filing affidavits. If there's any issue, you can tell the government to file an affidavit. There are competent law officers who can explain. So therefore, in this context, this bench of Justice Gavai and Justice Pardiwala giving a direction that you cannot, should not call officers at drop of a hat is very, very critical. Ultimately, both arms, which is the judiciary and the administration, have to have some mutual respect. What is happening is most judges, what new judges who come up lose track of what they should do, what they should not do. It is more in the nature of an administrative guidance given by the court to subordinate judiciary and to the High Court that please maintain the respect of government officers. Ultimately, they are also doing a critical job. It is not that they're interested in committing a contempt. They have respect for the court. If government officers are frequently called, the esteem of the court itself will go down. The respect of the court will go down. So it is very important that there's harmony between the two arms and judicial orders are implemented in a proper perspective without harassing an officer.
One supplementary question to you, Mr. Agarwal. This statement in the order says that the majesty of the court is undermined if it is issued at the drop of a hat. I saw some instances, these are these clips which are viral these days on video, where certain High Court judges are pulling up officers for their way of dressing, saying you should be in a coat and a tie. Since you have this experience in the courts of law do you think these are issues that need to be taken up by the courts of law? Somebody is appearing in a white shirt and a trouser. Is it insulting to the court, or are you hurting the majesty of the court by doing so?
See, what is happening is that the judges should also have that Lakshman Rekha. They are in the court to ensure that justice is done. The matters are heard. This is just waste of time, ridiculing a person, pulling a person's esteem and importance down. So the idea is a judge feels that I am God, I am a king, I am an emperor, I can say anything to anybody. But that's not so. Anybody who comes to court has a respect for the court. He has a regard for the court. What he's wearing, how he's behaving, all that is totally irrelevant. The job of the judge is to do justice, pass an order which is implemented. Now, with these kind of orders, what happens is the court attracts a lot of criticism, which is not necessary. Despite the Indian judicial system being flooded with litigation, judges being under so much pressure, they don't need this criticism. In fact, we have to kind of worship these judges for doing so much work in such short time. You see the court's docket. Every court has 60, 70, 80 matters a day. Now, in these, while dispensing justice, the judges are calling officers to the court, commenting on personal remarks. That's not really required. And the entire atmosphere is vitiated.
So, do you think the comments made by Justice Gavai and Justice Pardiwala were in light of all these experiences when they made this comment? This order is not just for this state of Bihar case.
No, it's absolutely correct. It's out of exasperation that the court has made these strong remarks. And we hope that this remark goes down to the High Court and the judiciary across the board, and it is respected.
Okay, point well taken. I'll go to Senior Advocate Nadkarni. You argued this matter. How did you convince the court that the High Court had been unfair to the bureaucrats?
See, basically, when the matter started, I told the learned judges, Honorable Justice Gavai and Honorable Justice Pardiwala, I said, in the normal course, we would not have come. This officer, a warrant has been issued against this particular officer. He's holding a rank of Additional Chief Secretary. And you expect the police to arrest him and to be produced in the court for what reason? Number two, this very officer had filed an affidavit. He had tendered an unconditional apology saying that I'm not in a position to attend the court. Now, ignoring all that, the learned judge records in his order that you are summoned, you are not here, therefore will, straight away. Then I pointed out, I said, please see what has been done here. I said, these are instances where this officer has already been summoned. A number of officers, the chief secretary, additional chief, all those top officials have been summoned. Just see in a 1 year period, 1 year block, there are about 140 or 160 appearances ordered of the officials. Number two, I said in this particular case, there is no grievance for the petitioner. Petitioner has absolutely no grievance in this particular case. He made a statement that the order has been complied with. That is also recorded in the order. So therefore, I mean, looking at these facts and circumstances, that you're calling the officer when, despite he having filed an affidavit explaining the position, what you wanted in the order, despite the petitioner himself saying that the order stands complied with, what was the need and requirement to call such an high officer of the rank of Additional Chief Secretary to the court? And number two, this Additional Chief Secretary had taken charge about a week back and he ensured compliance of the order. If you wanted anybody to be called for not complying the order for last so many years, you should have pulled up officials at that time who were occupying the position. Why do you pull up these officials? So their lordship, Justice Gavai and Justice Pardiwala, were convinced of this particular facts. Number two, I didn't even have to show any earlier judgments to them because both judges were reasonably well, acquainted with the law of the land. And that is how the order came to be passed.
Mr. Nadkarni, you have served as an officer for the government as the Additional Solicitor General of India. You know the extent of litigations that the government has with the court. What do you think is the issue? Could you delve into this issue further? Because there is so much of litigation. Do you think repeated summoning becomes essential for the courts sometimes? Or do you think that it is now become a par for courts, that it is now a habit that you summon And earlier, when the economy size was $600 billion, say 20 years ago, the work has increased, the scope and the demands from the officers have increased. But in tandem with that, the court's attitude has not changed. If you could delve into that from the government's view as well.
See, there shouldn't be a frequent and lackadaisical summoning of the government officials by the court. In fact, Supreme Court has said such things cannot be appreciated because this is nothing but the satisfaction of the ego of the judge. To this extent, the Supreme Court has gone. The Supreme Court has deprecated this practice of frequently summoning the top officials. And you have, as Mr. Agarwal rightly said, you have the competent law officers. If a government advocate, true it is that the matters can't go by default of a counsel. But if any government lawyer is unable to explain, you can always call the law officers. And we have competent law officers in this country. You can call the law officers, ask them to explain. And I'm sure all the law officers are very, very competent and they would be able to explain. There are cases where you are required to summon officials because certain things are not done, certain, you need a deeper appreciation of the facts of the case, or you need to know the ground realities, etc., which can't be related properly in the court by an officer of the court across the bar. Therefore, it is possible in a given case. But it can't be just, for the heck of it or at the drop of a hat, as rightly the phrase used by Justice Gavai in his order. So it can't be for that. You must have enough respect for the other wing of the administration, namely the government, the executive, the legislature, etc. So I think, and if you see, it says copy of this order be sent to the Chief Justice of the High Court. This is because it is required that the message should go all across. It should go to all the high courts and to the subordinate judiciary that you should not frequently summon these officials unless absolutely required. It is not that the official should never be summoned. No, that can never be the case. There could be circumstances and there could be reasons where the officials are required to be summoned. Suppose if there is a frequent non-compliance by the state or by a particular officer, or if there is a rank disobedience, despite the court having injuncted, the officer goes and defies the order of the court. You can not only summon him to the court, but you can even send him to jail in such cases. But those are different facts and circumstances, but that does not justify frequent and lackadaisical summoning of officials of the state administration.
I take this point to Mr. Mahesh Agarwal. A lot of young men become judges at the age of 28, 29, 30. And also now some people now get elevated to the High Court fairly early at 43, 44, 45. This message from the Supreme Court is, as a primer, they should also understand, is it a message because they feel that this message should be sent right down to the district judiciary? Secondly, I want to ask you, I remember a recent incident. The Noida Authority chairman was summoned. Senior Advocate Mukul Rohatgi appeared in that matter. I remember. I want to ask you that if there are important functionaries, deputy secretary level officers, or officers who are heading a municipal corporation or such places, who has a matter of day-to-day, have a lot of meetings, appointments, works. If senior advocates, much like yourself, you appear on VC so many times, can they be given that freedom or to appear online and maybe take part of the proceedings? Should they be physically summoned at all? I mean,
first thing is, why should they at all be summoned, whether physically or virtually? There are only two reasons which the court is doing. A, like Mr. Nadkarni said, if there is some clarification required, there is an expert view. For example, you'll recall during COVID times, the court was monitoring the various aspects of COVID. At that time, the health secretary used to remain present throughout in the court, also in the Supreme Court. It was important, it was critical because the urgency was such, there was no time to wait. A question is asked to a lawyer on some technical aspect, he can't answer. So the Solicitor General, Attorney General, they themselves call the health secretaries to participate in the proceeding. So interactive proceeding is there and orders are passed immediately. So where there are technical requirements and a person is required, the government officers appear themselves. They don't need to be called. They understand when it is required to be in the court, and the law officers also call them. We need your assistance. We need the court to be explained the issues. Second is compliance. So first part is getting expert views getting into the nitty-gritties. Sometimes technical requirements are there. A person is either called or he may remain present, which is absolutely fine. Second is compliance. There is no third reason why an officer is called. Now, insofar as compliance is concerned, if orders are passed and they are not complied with, the court gives a notice, affidavits are filed. There may be some justifiable reason because of which there has either been a delay or it is impossible to perform an order. Affidavits are filed, the courts consider them only and only if the judges feel that there is deliberate, wanton compliance, there is no interest in the officer to honor the judgment, only then a person can be called. So therefore, it's very carefully worded that drop of a hat. It's not that you call just for your ego's sake. There should be requirement. In fact, the court kind of suggests that when a particular judge requires a government officer to present, there should be some reasoning in the order itself that this is the reason why I'm calling the person. Either it's for clarification or for compliance. What is the reason? All these government officers, like you said, the Noida chairman, etc., they're performing huge public duty. They are also doing as important job as the judges. Now, for them to be dragged to the court and wasting public time, it serves nobody's purpose.
Very, very well spoken, Mr. Agarwal. I'll go to Mr. Nadkarni. The Supreme Court has given a message to, say, high courts and district judiciary. But the Supreme Court itself sometimes summons health secretaries of all the states of India. Now, on a given day, on a given date, it is highly unlikely that all the states could be able to send its secretaries. Do you think, because, and I ask you because you were the Additional Solicitor General of India, you understand how these things are done. Is it possible that all of them should be given a VC option for senior officers at least? Because to get them down to Delhi for appearing is not that easy. Is it possible as a matter of practice that senior government officers, the Noida Authority Chairman or some other authority chairman, say in the Mumbai Municipal Corporation Chairman, all of these, should they be allowed that in a sense facility?
Yeah. Tarun, I'll just come to that. But before that, I want to mention to you another incident. Allahabad High Court summoned the chief executive officer, a lady officer, to be present in the court in Allahabad High Court. That day on which she was supposed to appear came to be declared as a holiday. So she traveled by the first available flight early in the morning, which normally lands by 10:15, and you have to reach the Allahabad High Court. By the time she reached the Allahabad High Court, the matter had already been called out. The learned judge was informed that she is on the way, she is coming to the court. The judge said, "What do you mean coming to the court? The court starts at 10:30, she should have been here before 10:30. And he was told that, she has come, landed, and she's on driving. Issued a warrant against the officer, the chief executive officer. Against that, we came up. I appeared. The matter came up before a bench presided over by the learned Chief Justice of India, Justice Chandrachud. Justice Dr. Chandrachud, in fact, observed in that order that it was improper to summon and, issue a bail warrant against the officer, that too when the officer had present. This officer appeared in the court thereafter, and it was mentioned. The judge refused to withdraw the order or recall the warrant for the issue. So I'm just giving you an example to what extent the courts have gone before. Of course, the order came to be set aside, and then Justice Chandrachud observed in his order that some other officer can go. The chief executive officer need not be summoned to Allahabad. So I'm just giving you. Now the question about, summoning the officials by the Supreme Court all at a time, etc. It is obvious that VC option must be given. Because if you give VC option, you get the same thing, the officer appears through video conferencing. We have seen the advantage of, during COVID times, how effective this, video conference matters and how VC matters were being done. We see it today also because in Supreme Court, it's allowed on miscellaneous days on Monday and Friday. By these officers traveling, their whole day would be wasted. At times, even 2 or 3 days for certain areas. Money would be saved. Time, money, and energy would be saved. And this very time and energy, which would have been, involved in traveling and staying here overnight, etc., the officer can work at his desk and dispose of a couple of files and attend to certain important matters of the state. So obviously, it is but obvious that this VC option should be explored, and the officers, if required, as and when necessary, and absolutely necessary, they could be summoned or they could be asked to appear on VC and explain.
Okay, point very well taken. Now we move towards a round of closing comments. It is heartening to note that this message has come from Justice Gavai and Justice Pardiwala. Coming from the top, these things do make a difference. On bails, we saw the message from Justice Chandrachud had a difference. The court's attitude towards bails have changed. So these messages do count a lot. And also for the new judges, they get a message because they are new to the system. They will look around what's happening, and maybe, in the judiciary also, they look around what the others are doing. That's why these messages are important. I'll go to Mahesh Agarwal from Agarwal Law Associates for his closing comment.
So this was a very important message given by the Supreme Court as an administrative guidance. As you said, there are new people who are becoming judges. They're dealing with the government. Sometimes judges also in the courts get frustrated, saying that their orders are not being complied. So they feel that by calling an officer, a job will be done. Maybe there are bona fide reasons. But this message was very critical that please respect the government officers for the time. Respect that they're also performing a public duty. There is no real need of calling a person unless necessary. So it is still open for a court in a given case to call an officer by giving cogent reasons as to why the person is required, either for clarification or some expert views or for compliance. But drop of a hat, an officer should not be called, period. That's a strong message given by the court, and it was really needed.
Okay, I'll take this to Senior Advocate Atmanan Nadkarni for your closing comment on this topic.
Yeah, in fact, this judgment which has come of the Supreme Court is much appreciated. It's not only meant for new judges who have been sworn in and who have newly taken over, but also for the senior most judges, because some of these orders have been passed by senior most judge. And even the practice of Justice Chandrachud, Chief Justice of India, in his lecture, delivering a lecture at Cuttack in the High Court, observed about a particular judge who had made comments against an officer who had not come dressed properly to the court. So, these are matters. Incidentally, it is the same judge who had passed that order in the case of, which was dealt with by Justice Gavai. So I didn't want to make it very obvious, but I'm just telling you. So it is not that, and these were not new judges or anything. So even sometimes the senior judges, a matured approach is required. You may have the power to do so many things. You may have the power to send a person to jail also. But as Supreme Court says, frequent and lackadaisical, and Justice Gavai rightly calls it at the drop of a hat. If you start using these powers, then it will be only undermining the majesty of the courts. So more so the constitutional courts like the High Court and the Supreme Court must be very, very choosy and selective whenever they are summoning officials. And it should not be done at the drop of a hat. This message was very much required for our Indian judiciary across the board. And I'm glad that Justice Gavai and Justice Pardiwala have seen through things which are happening in the country. I'm sure they must have their own experiences also. And that is why this was very much required.
Thanks for explaining. And this whole issue towards the bureaucracy is an important stakeholder in the country's progress as much as the judiciary. It is heartening to note today that Justice Gavai, Justice Pardiwala have taken a stand for the whole judiciary. This message has been conveyed to the whole judiciary of the country. We hope that it will have the desired effect. I think Senior Advocate Nadkarni would be very happy that he played a role in this journey of this message being delivered. And it is by your appearance it happened. I think it would be a happy day for you. I would appreciate the fact that you both made time, Advocate Mahesh Agarwal from Agarwal Law Associates, Senior Advocate Atmanan Nadkarni, who participated, explained to us the intent of the judges. It is through people like you at the Supreme Court who are day to day that we get to know what the judges think, because of course you are there physically every day. Through you, we, the businessmen of the country, the general counsels, they get to understand what the court thinks. They are also stakeholders. They need to know what the judges think. Thank you so much for participating in today's discussion. And viewers, thank you so much for tuning in. Thank you so very much.
Thank you. Tarun, your program has been doing a wonderful job. And your program has been doing a very wonderful job. I must tell you, I've been watching each of your different episodes which you have been doing on various things. So you should also do it, because the recent orders passed by Justice Gavai especially insofar as the ED director is concerned, insofar as that bail to that lady Tista Setalwad, and even this yesterday's saying of the conviction judgment in a defamation case, what all the judges say, etc., will go a large way to enhance the prestige and the majesty of the Supreme Court. So these are all episodes, and I'm glad that you're doing all these episodes. So all the best to you. God bless you. Thank you, Mahesh, and thank you.
Thank you so very much.